Kia ora everyone, thank you for joining us on this video Q&A to talk about upcoming changes to our merger regime, how we plan on tackling them, and also how you can get in touch with us to share your views on the changes we're undertaking. I'm joined this morning by our Head of Mergers. This is Sam Holmes, he's on the right closest to me, and a little bit further away is Derek Johnston. He's the convener of our Mergers Committee here at the Commerce Commission. Thanks both for joining us. Sam, we'll start with you. You obviously run the mergers team here at the Commission, so could you just give us a little bit of a flavour to start off with? Tell us a little bit about the mergers team and the importance of the role they play.
Sure. So in New Zealand, it's illegal to acquire assets of a business or shares if that would be likely to substantially lessen competition in any market. And so our mergers team is responsible for monitoring markets and detecting any mergers that may breach that law or may breach it in future or already have, and to take action against those transactions in court as necessary. We also operate a sort of parallel merger clearance and authorization regimes, which are essentially processes through which merger parties can apply to the Commission for pre-approval of their transactions before they've completed. And this work is really important because merger result in permanent or at least very durable changes to market structure, and so it's crucial for the functioning of the economy that harmful mergers are detected and prevented before they take place. But it's also the case that many mergers are competitively neutral or even positive for competition. And so for those non-harmful mergers, we need to make sure that our processes are as frictionless as possible, which means being as timely and as efficient as they can be.
Yeah, and you mentioned timeliness, so Derek, we'll bring you in here. Obviously, we are, on a path to making some changes to our regime, and we've made some in particular around timeliness. So could you start us off by talking to that initially?
Yes, as Sam's indicated, we've got a process underway which will run over probably the next 12 or 18 months. We were looking to make a series of changes to our merger processes. And the reason for focusing on timeliness is that we're very aware of the importance to merger parties and their advisors of the time for decisions around our clearance processes and the impact which that has on their transaction timeframes. So what we're endeavouring to do is scrutinise our processes to see if we can streamline them and shorten them, but in a way that doesn't impact on our ability to appropriately and proportionately scrutinise merger transactions where appropriate.
And Sam, so we'll come back to you. So could you talk to us a little bit about what changes we've made so far to the mergers regime and I suppose the difference those have made?
Sure, so we can speak to two specific process changes. The first relates to the publication of our Statement of Preliminary Issues, or SOPI as it's sometimes called. This is a document that we aim to publish in the first 5 working days of a merger clearance or authorization application, and it's designed to solicit feedback from third parties on the merger. Now, over time, the time frame that it's taken to publish that document has slipped somewhat, such that in the last financial year, the average days for publication was around 13. Now, we've reflected on our internal processes and the board has approved some changes to the way that document is signed off internally, and that's had immediate benefits in terms of timeliness. So in the 4 months since that sign-off change was implemented, our average working days for publishing that document has fallen from around 13 to just over 5. And as further process changes, some of which Derek will speak to soon, are embedded, we hope to see that time shrink even further.
Yeah, and Derek, there's a few more that you're going to run through for us.
Well, the other significant change that we've made recently is related to the timeliness of publication of our written reasons for our merger decisions. Again, that was an area that over time had slipped and we believed was needed to be addressed. As a result, we've looked at our processes, our internal systems around getting to written reasons and made some changes there. Our objective now is to get written reasons out within 20 working days of our decision. You'll note that that actually aligns with the proposed timeframe for provision of written reasons under the legislative changes that the Minister has recently announced to our mergers regime. As I say, we've made changes to our processes, and since we've made those changes, we've made 3 merger clearance decisions. In relation to the first of those, our written reasons were published 20 working days after our decision. The second was published 3 working days after our decision, and the final one was published 0 days, or actually on the day of our decision. So there's been some significant improvement in terms of the timeframes for getting our written reasons published.
Yeah, Sam, obviously, thanks Derek, we've covered off some of the changes we've made in terms of speeding up the process, but could you talk to us a little bit about what applicants can do at their end, and I guess the importance of that as well?
Yeah, absolutely. So I think there are 3 things I would say there. First, engage with us early if possible. Secondly, prepare a high quality application to us. And thirdly, during the process, try and make sure that any information requests are responded to in as timely a fashion as possible. So just to unpack those a little bit, in terms of engaging with us early, we like to encourage merger parties to participate in what we call pre-notification discussions, and these are discussions with the merger parties before an application has been formally filed. We during that time are able to speak to the merger parties directly to understand a little bit more about their businesses, how the industry works, etc. We also are able to review their draft application if they've been in a position to provide that to us. And all of that is really beneficial for us in allowing us to get a whole bunch of work done early before the case has begun. Not only sort of administrative work, getting a case team together, pulling all the paperwork together that we need to start a process, but also substantive analytical work, getting up to speed on the likely issues and the markets and the industry in question. We're also able to provide feedback to the merger parties on their application in a way that ultimately helps that document to be sort of as targeted to the issues that we're likely to need to think about as possible. All of which sets us off on the right foot from day one. The second point that I was going to make there was in relation to drafting a high quality clearance application. And the key point to note here is that particularly in the early stages of our investigation, before we've had the chance to really reach out to third parties and do much of our own independent inquiries, your application really is the key document that informs our early understanding of the case. And so it's important that document is robust and high quality. And so a couple of recommendations there really. First, it's always better to anticipate the likely competition issues that will arise from your transaction, however unlikely you think they are, and to flag those up front and seek to address them, than it is to minimize or avoid discussing those issues. If the first time that we learn about a potential competition issue arising from a transaction is through third parties or our own independent inquiries, it can take us just that little bit longer to tease that out with the merger parties themselves and reach a concluded view. So in the long run, it is better to flag those up front to us. And the other recommendation relates to the information that you're providing us. So we have a clearance application form, or filing form as it's sometimes called, which sets out the information and the documents which we ask be provided to us up front before we're happy to acknowledge an application is full and complete. But as you're preparing your application, do consider whether there are any other documents over and above the documents required by that filing form that might also support or corroborate the submissions that you're making in your application. In other words, don't underestimate the power of internal documents. It's one thing, for example, to tell us that you regard yourself as constrained by or competing with competitors A, B, and C. It's another thing entirely to show us internal documents that you've prepared prior to the merger that demonstrate that you monitor those parties, that you react strategically when they increase price or introduce a new product or whatever it is. That can be really persuasive evidence. And then the third point I was going to make was ensuring that information requests are responded to in a timely fashion. So notwithstanding the fact that we do ask for information and documents up front in that filing form, we are also likely to need to make further requests, RFIs as they're called, throughout the life of a case, as we learn more about it, as we talk to third parties and so on. And so it can be really helpful for merger parties to identify someone internally as like a point person to receive those RFIs and respond to them. And ideally that person would have a good knowledge of how information and documents are stored within the organisation. They'd have capacity and resource to assist and so on. And ultimately all of that is with a view to ensuring that RFIs are responded to as quickly as possible. And from at our end, the Commission tries to engage with the merger parties as constructively as possible, understanding what information they have and what they don't, so that we can craft an RFI which is as minimally burdensome as possible while still getting what we need.
But it is crucial to have sort of that person on the ground, that one point of response from that.
Yeah, that can be really helpful.
Yeah. Derek, we'll come back to you because obviously, you know, we've been through a few changes, and change is really the word of the day. But there are others that are afoot. So I guess could you tell us about the Commission's plan to tackle those?
Happy to, Nick. There are essentially, I think, 3 key areas that it's worth highlighting at this stage that we're working through. The first relates to a review of our application form. Sam's already mentioned the application form. What we're doing is reviewing that at the moment, and what we're finding is that there's some information we ask for in the application form that in reality we don't actually need in many cases. So our intention is to strip that out of the form. But in addition, we're finding that there is other information that regularly we're having to go back to applicants to ask for, which obviously they have to then compile it, and that delays our ability to consider the application. So we're looking to set that out in the application form. So we think that these changes to the application form will in fact make it far clearer for parties engaging with the Commission as to what information we need to be able to progress our investigation at an early stage. We expect that before the end of the year we'll be coming out with the draft application form to consult with stakeholders and get their feedback on that. So that change to the application form, I think, is the first change. The second one, which is trickier that we're working through at the moment, relates to how we handle confidential and commercially sensitive information. And there are 2 drivers that are the reason why we're actually looking at this. The first is that we find on occasion during the course of our investigation of a merger, when we go out to get information, we have some parties who are reluctant to provide us with information, or on some occasions just refuse to give us the information because they're afraid that we'll provide that confidential information to their competitors, often the merging parties. And they're concerned we'll do that either because of our natural justice obligations or alternatively in response to an Official Information Act request. The second driver why we're looking at this area is that we're increasingly seeing interested parties come and make Official Information Act requests of the Commission, wanting to get hold of the information we've gathered during the course of our investigation before we've even made a decision on the decision. And in some cases those are legitimate, but each time we have to deal with an Official Information Act request, that does take time, quite an amount of time, and that slows down our decision-making process. So we're looking at these processes to see if we can strike the right balance in terms of getting the information we need and in a way that enables us to also deal with natural justice obligations. The third area that I'd highlight is just the changes that will necessarily come about if the legislative changes the Minister has announced get enacted. And what I'm thinking of there in particular are the stay and hold powers and call-in powers for non-notified mergers we've proposed. And secondly, our ability to accept behavioural undertakings as a condition of granting clearance. It's a power that we haven't had in the past. So we're thinking how we'll go about implementing and exercising those powers, and our intention is to put out guidance around those powers well ahead of that legislation taking effect. As you can see, there's a lot of change going on in the merger space, so the intention is that we will update our mergers and acquisitions guidelines once the legislation has been locked down. And again, we'll consult widely with stakeholders around those guidelines before we finalise those. So we end up with a set of processes that are user-friendly, comprehensive for those engaging with the Commission.
Thanks very much for that, Derek. Sam, we'll come back to you, almost finished, but before we get to our final question, I want to ask you a really important one, and Derek sort of mentioned this already, but in terms of stakeholders, how are they actually going to be able to give us feedback throughout this process? I guess what I'm asking is, how will you keep them informed?
Yeah, so we're really keen to keep stakeholders well apprised of the raft of process changes that we have coming up, and to get feedback from them on those changes. So for each kind of material process change that we have coming up, we do intend to undertake a targeted consultation on that change. If you would like to be involved in that targeted consultation period, if you would like to be consulted, then please do register your interest with the email address that I believe should be up on the screen now. Please get in touch with us through that email, and we'll make sure that we reach out to you on each new change that we've got coming up.
Excellent, thanks, Sam. And Derek, we'll come to you just to finish off. Could you leave us with some key messages for people that you'd like to leave them with?
Thanks, Nick. I think the key message I want to leave with people is, through undertaking this ongoing review process, what we're looking to end up with is a set of merger processes which are straightforward, efficient, and work for our stakeholders. And as a result, we're going to be consulting with stakeholders, and we're very keen for their input and feedback so that we have a workable and efficient set of processes while still maintaining an adequate and proportionate degree of oversight of merger transactions.
Yeah, I agree, Derek. I mean, this will be an iterative process as we roll out kind of successive tranches of process changes and try new things. And so, notwithstanding that we have these targeted consultation periods lined up, we're really keen to hear from people between and around those consultation periods with any feedback that they have. We're really keen to hear from you.
Excellent. Thanks very much, Sam. Thanks as well, Derek. And thanks everyone for joining us and watching this video Q&A. As you've heard, you will be hearing a lot more from us throughout this process, and the key here really is that we are keen to hear from you as well. But for now, mā te wā.